Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery. Today, it's called Important eDiscovery Case Law Decisions for September 2023. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console, and questions will be answered both during and at the end of the webinar. And the webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. And Kaylee Walstead, EDRM Chief Strategy Officer, is here. Can you tell us what resources we've got available today, Kaylee?
Absolutely, and so excited for this cult classic monthly series. Once again, we're having a lot of fun on our new On24 platform. Many more ways for you to engage. In your console, you'll see a question mark. That's where you type in your questions for today's faculty. The slides will be made available after the webinar has concluded. And if you click the paperclip for related content, you'll see a link to download the descriptions for the engagement tools to help you better engage, a link to subscribe to the eDiscovery Today blog and never miss a thing, a link to learn more about the Honorable Judge Peck and how to engage with him, and a link to check out Tom O'Connor's spicy new book, eDiscovery for the Rest of Us. Sounds like Festivus. And save your seat for next month's Case Law edition on October 24th. And up next on the EDRM webinar channel, October 11th, text, instant messaging, U.S. data privacy laws. Oh my, best practices for protecting your organization from growing litigation risks. There's also speaker bios that can be clicked and popped up to learn more about today's fabulous faculty. And just like Zoom, you'll see a smiley face emoji, and there's many more reactions that you can click. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform. You'll see the Twitter bird, which has not been changed to an X yet. You can follow EDRM on LinkedIn and eDiscovery Today on LinkedIn. And back to you, Mary.
Thanks, Kaylee. Well, our host and moderator today is Doug Austin. Doug is the founder and editor of EDRM Trusted Partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. And hailing from the great city of New Orleans for over 3 decades, Tom has stewarded the Gulf Coast Legal Technology Center. That's Tom O'Connor. He has written a new book, as Kaylee said, eDiscovery for the Rest of Us, and you can find that on his very spicy Techno Gumbo blog. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions and later on boilerplate objections, 502D orders, and technology-assisted review. We might even see a little bit of that a little bit later. And without further ado, Doug, do we have some cases today?
We do indeed, Mary. Thanks for the intro. And hi, everybody, and welcome to our September 23 case law webinar on the EDRM network. Yes, I know it's October, but this is our first chance to get on our webinar for last month. I also know it's 2023, even though my blog post yesterday morning might indicate otherwise. But you know, what can I say about that? You know, we all make mistakes. Anyway, if you like sanctions cases, we have them, including sanctions for discovery violations and misrepresentations, sanctions affirmed for spoliation of cell phone data, sanctions vacated for counsel in the famous smoking emoji case, sanctions for failing to preserve text messages, multiple sanctions against the defendant for multiple discovery violations, and one non-sanctions case with a very notable diagnostic protocol to assess adequacy of plaintiff's productions. And just a reminder, as Kaylee and Mary mentioned, we do welcome questions. We'll try to get to as many as we can, and we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. Normally, I say something clever here, like you should be sanctioned if you don't know that by now. But this time, I'll actually add an additional disclaimer that one of our cases involves a topic that's highly politicized, claims regarding the 2020 U.S. presidential election. Regardless, we're focusing only on the discovery implications of the case and nothing more. So please keep that in mind. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 32,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So, with that said, let's get into the cases. In our first case, the defendants moved multiple times to compel production of responsive communications, including text messages from the plaintiff's executives. On at least 4 separate occasions, as you see there in the first bullet point, plaintiff's counsel represented to defense counsel that it had produced all communications with third parties. However, at a hearing held this past May, it came to light that the plaintiff itself, not its outside counsel, had conducted searches, and outside counsel could not represent that it had exercised quality control over the collection of texts of all but one of Hedgei's executives. The court concluded by directing the parties to meet and confer to identify and remedy for any further issues, which led to a further motion by defendants to compel a thorough search of plaintiff's executives' laptop computers, which plaintiff apparently had not done at all. So the court issued an order requiring the search to be conducted at plaintiff's expense, with the potential to recoup costs depending on whether the search yielded duplicative documents. Guess what happened? Plaintiff produced thousands of new documents, including hundreds of text and Slack messages defendants had never seen before, including the type of messages that plaintiff had been ordered to produce in April 2022, and that plaintiff repeatedly represented had been produced. Whoops. So in considering sanctions pursuant to FRCP Rule 37A5A for plaintiff's discovery and violations and misrepresentations, New York Magistrate Judge Robert Lehrberger stated, given this series of events, the court must order Hedgei to pay defendants reasonable expenses, including attorney's fees, in moving to compel production of all communications from Hedgei executives to third parties concerning defendant Dale or the instant litigation. And in considering sanctions pursuant to FRCP Rule 37B2, Judge Lehrberger stated, Hedgei's conduct was hardly innocent and was more than negligent. Hedgei repeatedly misrepresented the extent of its compliance with the court's April 28, 22 order, and counsel failed to exercise sufficient quality control over collection by Hedgei's personnel. So Judge Lehrberger also rejected plaintiff's reminder that defendant Dale previously admitted to spoliating evidence, stating, courts in imposing discovery sanctions follow the maxim that 2 wrongs don't make a right. So Judge Lehrberger ordered plaintiff to pay defendants the reasonable expenses, including attorney's fees, incurred by defendants for the multiple discovery violations and misrepresentations that they met with discovery obligations. So Tom, here's another case where a party self-collected and outside counsel didn't properly manage the collection. What do you think courts need to do to force counsel to properly manage discovery of their clients?
Well, I mean, this is a tough one because, you know, there were constant, as the court itself said, misrepresentations by the firm that everything was okay, that they had produced everything. I know that, you know, when we get to the sanction stage, we're talking about the reactive part of the process, and how do you get to be proactive? And if at some point, maybe during early disclosures or the meet and confer, it comes to the court's attention that things haven't been proceeding the way they should have, they can get involved. And certainly the most recent rule changes, especially contemplated more proactive management by the court. But in the face of constant misrepresentations about what was done and multiple hearings, it appears, I don't know what else the court could have done in this instance. I mean, I'm interested to hear Judge Peck's perspective on this.
Yeah, I mean, hold them accountable would be a start. But and along those lines, Judge Peck, if you were the judge here, would you have applied some sort of sanction to plaintiff's counsel for failing to manage discovery properly and continuing to assert that everything had been produced?
Hard to say, because while this is in part a problem when a party does self-collection, here it appears from the opinion that it was the defendant's inside counsel, in-house counsel, that was doing the collection. Now, that person was not quite the fully neutral counsel, but in many cases, outside counsel does and can rely on inside counsel when that counsel knows how to handle discovery. This is a case where either that inside counsel didn't know what to do or, wanted to put their thumb on the scale of what was produced. I would also just note in passing, it's sort of ironic that the problem here was with laptops, where usually we see the problem with cell phone data or,
Right.
Other tools that counsel are not that familiar with.
Yeah, absolutely. The basic stuff, for sure. So first of all, a question, as we mentioned at the top of the hour, slides will be provided later on today after the session. So just to look for those via email afterwards. So Mary, what could the defendants have done here, if anything, to flush out the thousands of plaintiffs' missing documents sooner?
That's a really good question. I was interested in what Tom was saying about, the change in the rules to allow for more active case management. So perhaps the defendants could have been more out loud about that, but they certainly had protocols and they had orders and they were in court a lot, making a lot of requests. So I think from a technical and process standpoint, they might have been able to compare productions against each other to see what might be missing. If they use the EDRM MIH, the message ID hash, they'd even be able to do that comparison with emails. They could do a timeline analysis. They could do some clustering to see, to see where are the big gaping holes in this production. But that and certainly interrogatories and depositions, 30B6 witness, asking for the 30B6 witness or something like that. I mean, that's all I see. What do you see, Doug?
Well, that's a great point, because the 30B6 witness would certainly be another step that they could have conceivably taken. But it is interesting that their persistence ultimately did get to a point where they did flesh out that there were all these additional thousands, literally additional documents. So they did a great job of doing what they could to kind of show that, in this case, where there's smoke, there was fire. So good for them. So let's move on to our next case, which is the first of two appellate court rulings regarding sanctions we're covering this month, both of which were suggested by Judge Peck. This first one involved construction contractor Skanska and potential economic damages after its barges knocked out the Pensacola Bay Bridge during Hurricane Sally, where the district court ultimately concluded that Skanska had acted negligently. Along with the adverse verdict, Skanska was also sanctioned for spoliating electronic evidence under Rule 37E due to the fact that data from 5 out of 13 Discovery custodians' cell phones was destroyed. Even with an active litigation hold and actual litigation, Skanska did not back up the relevant employees' cell phones, nor did it suspend its ordinary cell phone data destruction policies. The district court ruled that Skanska acted with the intent to deprive the claimants of the cell phone data and sanctioned the company under Rule 37E2. The court emphasized that it saw no cogent explanation apart from bad faith for Skanska's systematic failure to make any effort to preserve cell phone data until at least 7 months after the litigation hold was technically in place. So it made 2 adverse inferences against Skanska and ordered it to pay the claimant's costs and attorney's fees for the sanctions motion. And of course, Skanska appealed. While noting that Skanska's in-house counsel had orally informed employees of an evidence retention policy and that counsel sent a formal legal hold letter, the 11th Circuit Court reiterated that Skanska did not back up its employees' cell phones, nor did it suspend its ordinary cell phone data destruction policies, not even for known electronic data custodians. Regarding the finding of bad faith, the Circuit Court stated, the court focused in particular on how the company took no action to educate its custodians and administrators about the litigation hold and made no effort to collect its custodians' cell phone data until at least 7 months after the litigation hold was in place. In the district court's view, bad faith was the only thing that explained the company's actions. If our review were de novo, this would be a close question. On the one hand, we find Skanska's utter failure to implement even the most basic data protection safeguards egregious, so egregious that an inference of bad faith is easy to make. On the other, this is not a case with direct evidence of bad faith. It is also plausible from this record that Skanska was just grossly negligent, but we review the district court's finding of bad faith for clear error, and an inference of bad faith here was not clear error. So the 11th Circuit affirmed sanctions for Skanska for the destruction of the data from 5 of its custodian cell phones. So Judge Peck, the Circuit Court noted if our review were de novo, this would be a close question, and that it is also plausible from this record that Skanska was just grossly negligent. Do you think the district court's finding of bad faith here was appropriate, given that Skanska did issue a litigation hold and did take some steps to preserve data in this case?
I do. Merely issuing a litigation hold is sort of the, if a tree falls in the forest, then nobody hears it, whatever. There should be some clear follow-up with employees. We've issued the hold. This is what it means. This is what you have to do, etc. So they didn't do that. The number of phones that were lost or recycled also is, to me, very troubling. The only question I have is whether it is appropriate in other cases to need to back up employee cell phones. Now, maybe most of these employees were those who worked on barges, which means they're working over the water. And, we've seen a number of cases where cell phones are lost in the water, probably in bad faith. But I could certainly see a barge employee dropping their phone in the water in absolute, accidents happen.
Right.
But it's a it's a review for abuse of discretion, not de novo. And the district court certainly, in my opinion, as well as the 11th Circuit's, did not abuse its discretion here.
Sure. Yeah, absolutely. So, Mary, last case we talked about laptop data. This time we are talking about cell phone data. So what recommendations do you have for our audience to address discovery of cell phone data and avoid situations like this?
Well, first of all, systemically, does the organization have a standard cell phone? I mean, have they standardized on Apple or iOS or a particular hardware for the cell phone? Or do they have a BYOD, either in fact or actually with a policy. And to make sure that those policies are up to date, especially around suspending retention rules. The other thing is that the policy that is and the practices that are created should give notice to the people whose cell phones would be collected, as well as their stewards, the IT stewards that tend to them, or the help desk that might repair them or send them places to be repaired. And it should be jurisdictionally aware, because there are different rules about preservation across the world. And so you want to know that. There should be a trigger for collection or for preservation by collection in certain cases. They may want to consider a mobile data management program, and serial litigants for sure will want to consider a cell phone collection platform.
Yeah, those are all great suggestions, and definitely something that would have been a lot more proactive than what Skanska certainly did in this case. So thanks for those terrific suggestions, Mary. So,
Doug,
go ahead.
Before you go to Tom, I would just add that it does appear from the opinion that at least some of the phones, if not all of them, were corporate owned and issued phones, because the opinion talked about a phone or multiple phones that were reset when employees left the company. That would indicate a company phone that they wanted to then reissue to another employee.
Yeah, great point, because that differs from the in-pork litigation, antitrust litigation that we covered earlier this year, where they were BYOD devices and not found to be in the control of the organization of Hormel there. So yeah, definitely a big difference. So great point. So Tom, this case is kind of deja vu all over again for us, because a couple of years ago we covered another case involving Skanska where they also received severe sanctions over the same Hurricane Sally event, including spoliation of cell phone data for 5 custodians. I don't know if they're the same 5, but what advice do you have for our audience regarding how to address ESI spoliation when it's relevant to multiple cases?
Well, I presume you mean the receiving party. How would they handle it in a separate case?
No, I'm talking about if you're a company who's realized your spoliated data and it ties into multiple cases. How do you address that?
What would Skanska do here?
Yes, exactly.
Other than run for cover.
There's that.
Well, I mean, the court points out some specific things. I mean, that occurred. Mm-hmm. There was an active litigation hold and then active litigation, but as they said, they didn't back up the cell phones, nor did they suspend cell phone data destruction policies. I don't know what you can do. If, as you said, it's the same 5 phones, the data's gone. If the data's gone, the data's gone. I guess what they could attempt to do is, if another case arises, try to deploy some sort of remediation. Right, look in other sources for the information. Try to see if anything was backed up anywhere else on a network or someplace. But this isn't a case of, well, we just didn't produce it, we collected it and withheld it. This is a case of it appears to be gone. So I'm not sure that they have a whole lot of options at that point.
The one thing I'd add, Tom, is the option of candor to the court. And that is to say, if you know from case 1 that you've lost the cell phone of an employee who's involved in case 2,
right,
better to go and tell opposing counsel and the court about that, early and promptly in case 2 or 3 or 4, rather than wait until the plaintiff or opposing side, whichever side you're on, figures it out. You get a certain, brownie points for honesty.
Yeah. I can say parallel type of situation, although it was a criminal case, the U.S. v. Morgan case up in Buffalo, where the U.S. attorney lost data, computers, and even the cell phone of the main defendant in the case. The judge dismissed, but without prejudice, and they refiled and continued to have problems in finding data and producing. So the solution there on the part of the producing party, the government, was to kind of throw in the towel and offer pleas on reduced charges to all the defendants, just because the judge had indicated that she was more than a little fed up and was about on the verge of dismissing everything with prejudice. So, yeah, candor with the court. Just, do what you got to do to try to salvage the case, I guess.
Right. Yeah. Get ahead of it as best you can.
Yeah.
So, yeah, great point. Just,
great. Thanks, Judge.
Yeah, absolutely. So our next case is our second appellate ruling, and it revisits one of our most interesting all-time cases, which is what I like to call the smoking emoji case. And in it, the plaintiff claimed sexual harassment and wrongful termination and produced this text exchange, which honestly looked pretty bad. However, after a forensic examination, New York District Judge Denise Coate stated this image is a fabrication. So why did she state that? Well, the plaintiff claims she received the messages on her iPhone with iPhone 5 with a cracked screen and ink bleed, among other issues. So she claims she took a picture of the text message exchange on the iPhone 5 screen using an iPhone X. But the image didn't show any screen cracks or ink bleed, and it also lacked photo metadata because it wasn't actually a photograph at all. But the clincher was the emoji she used, which was from iOS version 13, even though the iPhone 5 only supported up to iOS version 10, hence the smoking emoji. So the case was dismissed, and plaintiff and her counsel received monetary sanctions of over $150,000, which that came after we covered the case a couple of years ago. So enter the appeal, where the Second Circuit rejected Rosbach's argument that Montefiore knowingly and willfully lied to her counsel about how the cell phones of Rosbach's supervisor had been examined, rejected her claim that there was no perjury, referencing the overall incredibility of Rosbach's testimony regarding the origin of the text message document, and rejected Rosbach's argument that the district court abused its sanction by failing to consider lesser sanctions. But the Second Circuit vacated the monetary sanction against plaintiff's counsel, where they stated, instead of finding bad faith as is required for representational conduct, the district court applied Wilder's standard for non-representational conduct, finding that Altaras negligently or recklessly failed to perform his responsibilities as an officer of the court, including by disobeying the New York rules of professional conduct. As is the case with an attorney's fee sanction, a district court's failure to make an explicit finding of a lawyer's bad faith prior to imposing any sanction for representational conduct is a legal error that constitutes an abuse of discretion. We therefore hold that the district court erred by failing to expressly make the finding of bad faith required to support the sanction it imposed against Altaras and DSLG, and accordingly vacate and remand for application of the correct legal standard. So, Mary, are you surprised that Rosbach argued that the district court erred in its fact findings that Rosbach testified falsely, given that the image she was testifying about was determined to be a fabrication?
Well, I was surprised by the whole case. And I guess wishing will not make it so.
Right.
I think it was the only way they could say that the decision was clearly erroneous was to go at that testimony. But one piece of this case I think we could take a lesson from is, and that's the confusion over a forensic collection, that like an evidence grade collection that doesn't change the metadata versus a forensic image in investigation. I think they were a little hung up on the difference between those two things. Mm-hmm. In this case. Yeah.
Yeah, absolutely. Because obviously there's what we call a forensically sound collection that isn't necessarily a bit by bit collection, but still gives you some level of metadata and preserves metadata. That's key to it. So yeah, great point. So Tom, as soon as it became apparent that Rosbach had fabricated evidence, how should Altaris and DSLG have handled the case?
Well, I'd want to get in front of the judge immediately. I wouldn't let it, I don't know what the status of productions here, whether they were rolling production or it was a one-time production, whatever. But as soon as I encountered something that was clearly fabricated, I'd want to get it in front of the judge. I then want to also get my own forensics person to look at everything, to see if there were other fabrications throughout the entire chain of the production. If it happened once, statistically speaking, once something happens, there's a 50% likelihood it's going to happen again. I want to examine everything with an expert and get in front of the judge as soon as possible.
Yeah, well, and maybe even when you have a client is fabricating evidence, it goes so far as maybe even consider withdrawing from the case. We saw that in a case earlier this year, where that became apparent.
I guess I should have been more glad. That would be part of getting in front of the judge. You're going to need the permission of the court to do that at this stage. So you want to get there as early as you can.
Mm-hmm. Yeah, absolutely. So Judge Peck, the Second Circuit found that the district court failed to make an explicit finding of Altaris's bad faith, but the district court did find that Altaris negligently or recklessly failed to perform his responsibilities as an officer of the court, including by disobeying the New York rules of professional conduct. So even if the district court fails to sanction him upon remand, can he expect any other consequences from his actions in this case?
Now, first of all, and I know nothing about what Judge Coate will do. I've not talked to her about this case, but I suspect that she will indeed do what she needs to do to dot the I's and cross the T's and sanction Altaris and his firm, particularly because I would assume in this sort of employment discrimination case that Ms. Rosbach is not going to be paying the sanctions that were ordered, so a deep pocket would be useful to Montefiore. But in any event, assuming she doesn't, this case and his conduct in it will follow Altaris, for the rest of his career. And I am sure every brief in other cases, at least with lawyers smart enough to have done their research, will say something like, counsel for the plaintiff, Mr. Altaris, who was sanctioned in another case or who was, found in another case to have done blah, blah, blah. That line will be in every brief in cases against Altaris.
Yeah, that's true. That's a pretty significant I guess, consequence of their involvement here. So yeah, it will certainly be interesting to see what happens upon remand. A comment from the audience, notably the Second Circuit affirmed that dismissal for spoliation was appropriate under Rule 37E2, but turned to inherent authority to award fees because of the bad faith. So obviously we get into the Rule 37E versus inherent authority discussion, that we've gotten to in a couple of other cases. So yeah, just when we thought this case was dead, there's still a little bit of life left in it. So we'll have to see what happens in that follow-up. And we'll move on to our next case, which is, it's the one I experimented with ChatGPT to summarize the case. Sadly, most of what you see on the slide here was left out of its summary, so I still had to kind of write it up and provide it. So in this employment discrimination case involving claims of wrongful termination, Miramontes sent Peraton a litigation hold letter in July 2021. In the letter, Miramontes placed Periton on notice to preserve all documents regarding his claims, including information, data, emails, texts, attachments, and any other method or means of communications internally and/or externally. In turn, Periton directed Miramontes' direct supervisor to preserve emails relating to Miramontes' claims, but did not mention text messages. At his deposition, Stenberger testified that he texted his supervisor about Miramontes once or twice. He also stated that he received a litigation hold letter from Miramontes, added that he read only the first paragraph of the hold letter and was unaware of any duty to preserve his text messages, claiming he deletes all his text messages within 48 hours. First addressing the control issue, Texas District Judge Jane Boyle stated, "Here the court finds persuasive Miramontes' evidence that Periton did not issue company cell phones and Periton employees regularly conducted business on their cell phones. Under these circumstances, the court finds Periton had control over the text messages between Stenberger and Capalvo." Judge Boyle also added, Periton had a duty to preserve these messages because a reasonable fact finder could conclude they were relevant to Miramontes' case. Stenberger intentionally destroyed the text messages, and Periton is vicariously liable for this destruction. And Periton's failure to tell Stenberger to preserve these messages, despite Miramontes specifically requesting that it do so, evinces bad faith. So what sanctions did she find appropriate for this bad faith spoliation? Denying Periton's motion for summary judgment and permitting Miramontes to serve 5 additional interrogatories and 3 additional requests for production. So, Tom, do you think 5 additional interrogatories and 3 additional requests for production is a severe enough sanction for intentional deletion of text messages?
Well, it doesn't feel that way. You know, when the court specifically says that they found bad faith, the court's own words, Judge Boyle said, this evinces bad faith. Mm-hmm. I mean, some sort of an adverse instruction, perhaps, and maybe that's still on the table. Sure. You know, maybe the court's saying, okay, let's see what happens with these additional interrogatories and requests. And I haven't closed the door on further sanctions. I don't know, but yeah, it just seems like really that's it. You get to deliberately, in bad faith, destroy evidence, and the sanction is
more discovery. Right. Well, yeah, because it didn't seem explicit that she was withholding those potential more significant sanctions as a potential follow-up.
It didn't seem to say that in the decision, no.
Right, yeah. Exactly.
In the order.
Well, so let's compare a couple of cases here. Judge Peck Skanska received much more severe sanctions for failing to preserve cell phone data in their case than Periton did in this case. Do you think there are circumstances in that case that warranted more severe sanctions that weren't present here?
I do. I think the cell phone data in Skanska likely was directly relevant to the issue in the case of what happened. How did the barges break loose? Yes, it was a hurricane, but what happened? And that goes directly to whether Skanska was entitled to prevail in its limitations. Here, the issue is, was he discriminated against when he was terminated allegedly as part of a reduction in force? The after termination text messages, I suppose they could have said, oh, heck, we discriminated against him because of his age. How do we cover it up? But there was no evidence that that's what they were texting about. So it's more likely to be a peripheral issue that the text addressed. Also, by denying Periton's summary judgment motion, the court is saying, okay, go to trial. And it would not surprise me that Judge Boyle was figuring that if the defendant company had to go to trial, it was going to settle the case favorably for Mr. Miramontes. So, all of that was applicable. I am surprised. I mean, you and Tom were talking about the adverse inference. I'm at least surprised that the court did not award attorney's fees to Miramontes. He was represented by counsel in this case. Now, maybe his request did not, his motion didn't ask for attorney's fees. We don't know that, but one would think that would be the bare minimum when you win on a motion like this.
Yeah, absolutely. That was surprising as well. So yeah, this case had a few surprises. That was certainly one of them. So Mary Stemberger said that he read only the first paragraph of the hold letter and was unaware of any duty to preserve his text messages. So what recommendations do you have for our audience to ensure that custodians are fully aware of their preservation obligations?
Well, isn't this an advertisement for a preservation system? So,
right.
Exactly. So the notice itself, of course, should have an acknowledgement that the reader of it acknowledges and triggers that at the end of the notice, so that you know that they've at least rolled their eyeballs over it to get to that point where they can acknowledge it. The hold notice should also have a phone number so that if people have questions, they can call. In this instance, probably the person wouldn't have called. So the onus is on the attorneys to provide some oversight. And they can do that by sampling the responses for understanding, for completeness and understanding. And they can also focus on the key actors, people that they'd like to put on in the witness chair, or those that look like they might just be loosey-goosey with their data. You focus on those, make sure that everybody knows what they need to do for the hold, and cover your 26G obligations.
And I would add to that, don't just say, preserve everything or preserve documents, NESI, knowing that people don't focus on texts and Slack and et cetera, et cetera. It may be dangerous to list things because you'll leave something out, but I would say make sure you are educating the employee that texts and other things are indeed covered by the preservation obligation.
Mm-hmm. Yeah, absolutely. No, all great points. And certainly,
Excellent.
Yeah, and certainly some custodians are more notable than others. You would think the direct supervisor, the person alleging employment discrimination, would be one you would pay particular attention to. So that probably requires a little more follow-up as well. So yeah, definitely some great suggestions there, and an interesting case. And we'll move on to our next case, which is that highly politicized case I mentioned at the beginning, and which was actually suggested by one of our followers, Matt Linehan. It started out reasonably normally, as you can see in that first bullet point, but from that point on, discovery just kind of went haywire. Giuliani, through counsel, advised plaintiffs that the FBI had seized his electronic devices in April 2021. Those devices were returned. Giuliani claimed he lost access to some of these accounts after the seizure, and he and his counsel would need to assess the status of those accounts. Still, Giuliani's counsel pointed to a data set held by an eDiscovery vendor with assurances that the data set contained all the data collected by the FBI from the seized devices. Giuliani produced 193 documents, all from that data set, but subsequently claimed he couldn't conduct additional searches from it because those documents had been now archived because he was over $320,000 behind on payments. When the plaintiffs requested confirmation from Giuliani's counsel that Giuliani had taken reasonable steps to preserve his electronic evidence, Giuliani's counsel replied, "I am not aware of his preservation efforts." During his deposition in March, Giuliani testified that he typically had two phones and has a bunch of inoperative phones, though right now he really has officially one phone. He had a Gmail account and then several offshoot accounts like rudygiuliani@me.com and a Proton Mail account, and he sent messages on Twitter, Signal, Telegram, and WhatsApp around the time of the 2020 election. Plaintiffs also never received any discovery from Giuliani's businesses, leading to a motion to compel, which Giuliani did not oppose, leading to a judgment to pay plaintiffs' attorney's fees of $43,000 plus. He also submitted a personally executed and unsworn stipulation that purported to concede all factual elements of plaintiff's claims for the purposes of this litigation in response to their request for default judgment sanctions. So DC District Judge Beryl Howell, noting that Giuliani assured the court he understands his obligations because he had been doing this for 50 years, stated, in this case, however, Giuliani has only given lip service to compliance with his discovery obligations and this court's orders by failing to take reasonable steps to preserve or produce his ESI. The bottom line is that Giuliani has refused to comply with his discovery obligations. Judge Howell also stated the result of these efforts to obtain discovery from Giuliani, aside from his initial production of 193 documents, is largely a single page of communications, blobs of indecipherable data, a sliver of the financial documents required to be produced, and a declaration and 2 stipulations from Giuliani, who indicates in the latter stipulations his preference to concede plaintiff's claims rather than produce discovery in this case. Giuliani's stipulations hold more holes than Swiss cheese. Well, that's a visual there. So Judge Howell issued default judgment sanctions for Giuliani under both FRCP Rule 37E2C and 37B2A6, directed Giuliani and his eponymous businesses to produce records and information prepared for a trial on damages in order Giuliani and his businesses to reimburse plaintiff fees and costs for an additional $89,000 plus to go with the $43,000 plus previously ordered, plus interest, and for Giuliani to reimburse such attorney's fees and costs associated with plaintiff's motion for sanctions pursuant to Rule 37E, which we haven't even seen what that total is yet. So, Judge Peck, have you ever seen a party concede its opponent's claims to avoid producing discovery? How would you handle that situation, a situation like that as a judge?
I mean, I did have it in a very rare, less than a handful of cases where the defendant withdrew their answer or the plaintiff withdrew their complaint or whatever, leaving just damages to be determined or something like that. But I certainly never saw one where the party had the chutzpah to say, okay, I'm stipulating that the other side wins, but I want to be free on appeal to claim that they didn't win or shouldn't have won. That's the Swiss cheese holes here, and that is certainly unique in my experience.
Yes, indeed. So certainly one of the things, obviously, most of our cases don't get covered by all the major news outlets. This one did. So Mary, have you ever worked on a high-profile case like this? How would you handle discovery any differently on a high-profile case like this, if at all?
Well, the high-profile cases need to be staffed, and they need to be overstaffed, and they need to have at least one project management with a manager with a backup. The project team should probably have a liaison to crisis communication as well, since it'll be in the news. And the people on the team will need training on how to comport themselves in public. Should they be talking about the Giuliani case, or should they give it a case nickname so that if they're on the train and they're talking, or at home and their family is listening in for perhaps, so to keep things confidential. And then also these high profile cases, the people who work in them, and this is nothing to do with this particular case, but they tend to, throw their service providers or their attorneys under the bus. So it's important that everything be in writing, all communication. Like if you're neutral, the communications with the parties need to be witnessed by all the parties, being very careful about ex parte communications, all of that. It is it's a long slog and you're on a high wire. And so you want to make sure you have the absolute best team and open door policy so that people can surface issues early before they hit the front page of the New York Times or the Wall Street Journal.
Yeah, those are all great points. Yeah, I've seen the whole code word used to describe a case, tactic used particularly. So that's a particularly interesting one that people can do. So great point. So Tom, here we are again. Seems like there's another case where apparently counsel wasn't actively on top of discovery. At least it seems that way when they say they're not aware of his preservation efforts. So, but it also sounds like they were dealing with a difficult client. So does that mitigate the blame for counsel at all?
You think he was a difficult client?
Well, maybe.
Here's the thing. I think there's a difference between my client turns out to be a difficult client and signing on with somebody who you should reasonably know is going to be difficult. It reminds me of that scene from the first Pirates of the Caribbean movie where Jack Sparrow's in the sword fight and his opponent accuses of him cheating, and he looks at him with this look of surprise on his face and says, "Pirate?" What did you expect? Right? So, in the normal course of events, maybe that would let the lawyer off the hook. This one, I think that's going to be a little difficult. And I think that's compounded by, my goodness gracious, do you really want to go on the record and say, I am not aware of my client's preservation efforts? Maybe not your best argument there, counselor. So I don't know. I don't know in this case if that's going to get him off the hook.
Yeah, no, I think that does seem like an odd statement to make, regardless who your client is. So, definitely a very a big mess discovery-wise. I'm going to focus on discovery, and we'll leave it at that and move on to our last case. Which is the only one this month that isn't a sanctions case, well, at least not yet. Here, the court appointed Special Master Maura R. Grossman in May to address and resolve all issues raised by the defendants regarding the initial plaintiff's use of TAR and the initial plaintiff's collection and production of documents from additional custodians. After meeting with the parties, Special Master Grossman provided 2 sample validation protocols that she had developed and used in prior cases. One from Judge Peck's Rio Tinto case, where he famously declared that it is now black letter law that where the producing party wants to utilize TAR for document review, courts will permit it. One of our most famous cases in the past dozen years. And the other from the broiler chicken case, that protocol from, I want to say, maybe 4 or 5 years ago. She requested that the parties review the 2 protocols and advise her as to whether they agreed that the suggested approach of gathering some empirical data first would be a better way to proceed for now, and if so, whether they preferred the Rio Tinto protocol, the broilers protocol, or some combination of both. Initial plaintiffs favored aspects of the broilers protocol, while defendants expressed a preference for certain elements of the Rio Tinto protocol, but defendants indicated there were still certain gating questions that the initial plaintiffs should be required to answer before proceeding to such a validation protocol. When defendants submitted an alternative, slightly modified validation protocol, Special Master Grossman agreed with the plaintiffs that what defendants sought was unduly burdensome, overly complex, noting that the defendant's draft protocol would appear to require the review of over 86,000 documents simply for the purpose of confirming that there's a problem with the TAR process and trying to determine where it might be. Instead, Special Master Grossman developed a more reasonable and proportionate initial diagnostic process that does not invade work product and that will assist the parties and the Special Master in moving forward. So while it's difficult to provide more than a high-level summary of it, even on a blog post, much less a PowerPoint slide, I can say that the initial plaintiffs were ordered to complete a prevalence exercise which required the plaintiffs to provide metrics and responses to 35 requests for information, a stratified sampling, aka broilers exercise, which required the plaintiffs to conduct 8 random samples totaling 6,000 documents to be randomly arranged and reviewed again by subject matter experts who would not have information of how the documents were treated previously, and a declaration attesting under penalty of perjury that initial plaintiff custodians did what they were supposed to do and the information provided in response to was accurate and complete to the best of the declarant's knowledge, information, ability, and belief. Based on the information provided, Special Master Grossman would then perform calculations set forth in the appendix to the order and supply the results of those calculations to the parties for their review and comment. I highly recommend you check out the actual case. You can get to it via the link in the slide, and then a link on my write-up of it for the actual detailed protocol, because it is very interesting and noteworthy to explore that. So Mary, obviously a protocol like this isn't for every case. In what types of cases is this level of validation and scrutiny appropriate?
Well, I would say that I agree with Dr. Grossman that quality control is always appropriate, even in cases where you're just using search terms, just to belt and suspenders your productions. But why not have a standard set of metrics to exchange, and then maybe some bespoke samples could be taken, so that because not. It won't fit every single case. But you'd have to have some money. You'd have to be technically savvy. And you may have been previously sanctioned or had some curative measures against you. You need to be experienced in eDiscovery law. You have to be experienced in TAR. You need some SQL help if you're going to do a protocol like this. It's pretty involved. You definitely need your help.
Yeah, absolutely. And of course, this is kind of a company versus company kind of case, which is high stakes. And obviously both sides presumably have considerable resources to bring to the table. So that's notable there for sure. So Tom, do you think the fact that Special Master Grossman started the process with 2 prior protocols with which he was involved before helped expedite the process, or would it have been better to start with a clean slate without any previous examples?
Well, I'm not sure if it helped expedite anything, since they immediately started arguing about which one was better. But protocols are consume maybe 50% of my consulting business and are an enormous problem. If Maura Grossman wants to give me 22 sample protocols, I'm going to take them and look at them and sort through them. I mean, rather than start from scratch, especially in a case that is maybe a little more complex than average, I'd welcome all the assistance I could get from Maura Grossman.
Sure. Yeah, absolutely. And it certainly helps to see what's been done before, and use that to kind of help guide what you can do on this case. And so Judge Peck, obviously, as I mentioned, Special Master Grossman worked with you on the Rio Tinto case, and that was one of the 2 protocol examples she used here. So in a case with complicated issues like this, when is it appropriate to bring in a special master, and how much coordination is appropriate between the judge and the special master to address the discovery issues?
A lot depends on the philosophy of the court. Appointment of a special master was a rarity in the Southern District of New York and in many other federal districts, because the magistrate judges did all the heavy lifting, or almost all the heavy lifting, in resolving discovery disputes. Some state courts, for example, I mean, I've been appointed special master in 3 cases, none out of my old court for the reason I've just mentioned, but 3 out of the commercial division of New York State Court. Remember that magistrate judges are free to the parties, but they've got to pay at least one side, if not both, for a special master. Nevertheless, and I certainly recommend that everyone read the EDRM guide on the use of special masters. I'm not sure if that's the exact title, but it's pretty close. Often save the parties money in the long run, because there are techniques the master can use to get to the heart of things without as much delay or cost as motion practice in front of the court. in Rio Tinto, just as an aside, I didn't really work with Mora. My work was convincing the parties that they were willing to have a special master because I didn't want to appoint one at their expense without their consent. And so I spent a certain amount of time begging, pleading, suggesting. Then they finally agreed. I appointed Mora, and she issued her protocol decision in Rio Tinto. And thank goodness nobody took any objections or appeal to me from it. Masters are very useful in cases like this, where the judge doesn't have the time and or the expertise to develop things. And there are special masters who just would do regular discovery disputes, sort of let's keep the trains running and et cetera. And Professor Grossman, who is an expert on tar. So I'll stop there.
Okay, yeah. A question from the audience about the two protocols that she provided. Aren't they already out of date because they apply to TAR 1.0 models, simple learning, as opposed to TAR 2.0 continuous active learning, which uses illusion testing, or even TAR 3.0, which is a clustered offshoot of continuous active learning. Is that a valid point?
I mean, yes and no. Rio Tinto was definitely a TAR 1 simple case. I don't remember the TAR process in Broiler, but no matter what you're using, there still should be some validation at the end. I'm not sure that the level of detail that Professor Grossman prefers is necessary, but some validation, whether it's a more simple illusion testing as the questioner implied or something else, still needs to be done.
Yeah, I just would say that there's also basic concepts that need to be deployed, especially as the judge says at the outgoing end. But some people are still using predictive coding. We don't know what tools were being deployed here, so I'm not sure they're that far outmoded.
Sure. Yeah. And obviously, I assume that there were some specific, attributes to the particular approach here. Plus, Mary brought up a good point: is that people should be doing testing for search terms as well, for their results on search terms, and people don't seem to do that, but they seem to think it's a must for TAR when not for search terms. So. Certainly interesting concept and a very interesting case. So
for those who want to read more about this sort of testing, read the decisions in the diisocyanates litigation, where both the district judge and my former colleague Jay Francis, sitting as special master, dealt with various validation questions, one of which was Professor Grossman's acting in her capacity as a lawyer or a lawyer or expert for one of the parties, as opposed to being the special master.
Yeah, great case. And once again, Judge Peck, you managed to get in that D word that I can't ever pronounce. So nicely done. So that takes us to the contacts page. And we have another case law webinar coming up in just 20 days on October 24th, just a week before Halloween. Be very afraid if you're me and you have to cover 6 cases in 20 days. Until then, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. Thanks to you all for your comments and questions. And I'll turn it back over to you, Mary, to close us out.
Well, thank you, Doug, for anchoring, and our thanks to Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to you, the EDRM community, for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thanks, everyone.
Bye-bye.